The conference is coming to the end, so my last presentation here will be more of philosophical nature. We will look at the liability with a broader perspective, with thinking about what the mediator should really be responsible about. As you all know, the mediation officially started in Europe by the directive adopted in 2008 on mediation in civil and commercial matters. And if we check this directive and look for the words liability, responsibility, being in charge of, then we can see that only in 5 tiny places we can see these terms. And none of these articles give us understanding what the mediator should be liable for. So that's what happened, is that in all 28 European Union member states, every country of us understands liability differently. And the case law is different on liability. So the situation actually hampers free market and creates obstacles to free market in the European Union, because one mediator working in one member state can be liable for one thing, and the mediator just across the border in another member state is liable for completely different aspects. So how dangerous is the profession of mediator? I've heard from people who are not related with mediation profession saying that it's not so hard to be a mediator, just ask how you feel and listen carefully. But well, it's not so easy at all. A colleague from Italy, Francesca, in another conference shared us a wonderful case which recently occurred in Italy, where the mediator was held by court civilly liable for preparing a bad agreement, although not the mediator prepared the agreement, but the lawyers did, and it was just signed in the end of mediation process. So could we imagine in Latvia, maybe even Lithuania, that the mediator could be held liable by the court decision about the agreement prepared by other person, which was consulted even by the lawyer? So this diversity is really huge, and it causes it poses the mediators in a very dangerous situation, and also it places the clients in a dangerous situation. So clients, when choosing a mediator, should know in advance according to which jurisdiction the relationship issues will be analyzed. So if I choose a mediator from Italy, will our relationship, like client and mediator relationship issue, be reviewed by the laws of Italy, and will I be able to get compensation in the case of bad work according to Italian laws? And actually, how much damages possibly the mediators can cause to the clients? Can you imagine any situation when mediators can really cause damages or do some harm to the clients? What exactly you should do to harm the client? Like bad consultation, but mediator is not a consultant. Bad agreement, but mediator is not a lawyer. Like ill treatment of psychological aspects, but mediator is not a psychologist. So what exactly the mediator is liable for? And there is no strict answer. And even if there is, the answers differ from country to country. Understanding of civil liability of mediators differs really significantly across the world and across the European Union, and there are a number of cases published on internet where mediators have been held liable for events which happened nearby the mediator's even office when the clients were coming to the mediation room. So the borders are quite open and quite dangerous, and it seems from the development of the world and from the development of the European Union that the liability will only increase. Society, like safe society, which we have in European Union, demands higher protection, higher certainty, higher guarantees, higher predictability, and it's not there is no even hope that it will go down. And we can look at this mediator's liability from 2 extremes, from 2 poles. There's one approach that mediator is a result-free profession. So which means I just talk to my clients and I don't care will they benefit from the process or no. So I'm not liable for the result which I do in the process. At another extreme is excellency of profession. That mediator is a super profession representative holding capacities of lawyer, psychologist, economist, tax consultant, etc. So, which is unrealistic approach equally. And although I'd like to have such a professional, let's be realistic, we live close to 100 years but no more. So not even a perspective to gain such abilities. There are different obligations which the mediators currently hold, like obligations in general, formal obligations, facilitative, evaluative, and etc. Confidentiality obligations. So should mediator be liable by breaching? Should be liable like economically if he breaches these obligations? And how should possibly each country analyze this relationship between the mediator and the parties? There should be good contractual relationship, but even if the mediator, with the aim to protect his own responsibility, drafts a very good contract with the client, it doesn't save us very much because there are still civil laws in each of the particular country which can exceed this liability if the court, by the case law, establishes that mediator should be higher responsible. Even the mediator's criminal liability could be analyzed in a particular situation if some financial harm is done to the client. In Latvia, if we analyze Latvian mediation law, we see quite vague, and well, thanks God, so far, quite vague obligations of the mediator to conduct a mediation, to conclude agreement with clients, to explain procedure, to observe basic principles, to observe professional norms. And if we analyze the complaints which have been raised against mediators in Latvia, and there have been already some, then one of these complaints was about the fact the mediator drafted a contract which was, according to client's opinion, not of sufficient quality. So by checking the particular contract between the client and the mediator, we could see that the mediator promised to draft agreement, and the draft agreement was prepared. But how far should we then go when the satisfaction of the client will be reached? If the client continues asking more improvements of the agreement, include new clauses in the agreement, reshape the agreement, there should be some borderline where we should say that mediator has done its job. So it's again very open to the case law, which probably will be coming in next years in all the countries. And let's even forget about the perspective that the law will regulate that all. It is not possible to make an instruction and to regulate that. Instead, probably the case law will provide an answers. And mediator has also professional duties, like client handling duties, administrative duties, which the mediator should do to maintain the profession, and the corporate duties, which the mediator should have as a member of a mediator society. When I was participating this time just as observer in the mediation tournament, wonderfully made in Rone University in Vilnius this winter, I was amazed to see that students, representatives from different countries, in fact, shows very diverse mediation. That how we see what mediators should do in Latvia completely differs from that what mediators are doing in other countries, which means mediators are working differently, and each country expects from the mediator different behavior, different outcomes. So even in this aspect, we cannot compare where the liability is, because well, the country is just setting different principles for mediators. And here is also an example from the Italy inheritance law case where the mediator was held liable. And this is a very dangerous decision for not only for the Society of Mediators in Italy, I think for the Society of Mediators all over the European Union. But well, luckily the Italian mediator was protected by the mandatory civil liability insurance, which is my next slide. How about mandatory civil liability? There are countries where civil liability is insured. And these countries are, for instance, the Netherlands, Italy, Austria. And the limits of liability is, you can see these numbers, 400,000 and 500,000. In comparison, again, to Latvia, we even have notaries. The insured sum is just 71,000 euros, where mediators have such amount of insurance. And if you analyze the development of liability insurance in particular country, you can see the more developed are liability insurance of some profession, the larger are number of claims against particular person. So from one side, existence of existence of insurance of civil liability protects the mediator. But from other side, it opens a temptation and doors to court cases against that particular mediator. If we know that mediator is not insured, we don't have any financial interest to sue that person. Probably there will be nothing to get from the person. But if the person is financially protected with insurance policy, welcome to the court. And probably this case will be then resolved also by mediation. So I leave my presentation with this questioning mark in the end by asking where the liability of mediators go, how it will be developed, and let's think about our protection as mediators. Let's define more clearly in the context with clients what we are liable for, and stay active also in the case law analysis and show the position and opinion about how the case law should develop in the mediation field. So I thank you for your attention, and I also want to thank with these words said by Mitt Romney that leadership is about taking responsibility and not making excuses. And as mediators, we are ready to take responsibility. But we also want to have some clarity about what should we be responsible for. Many thanks for your attention.